So next concept that we have from unit 3 is negligence, right? Again, negligence can be act also or omission also, right? What is act? It is doing something which a prudent or reasonable man would not do. That means you are doing something which you are not expected to do. Maybe entering, negligence, right? Maybe you are not taking the reasonable care that you should have taken, right? If there is some heavy machinery inside a factory, what you need to do is you need to follow the safety measures, right? You need to wear proper safety equipments and other stuff. You are not doing it. That means there was negligence from your end. What kind of negligence? It was by act, right? You did some act which a prudent or reasonable man would not do. Without having knowledge about how that machinery operates, they would not straight away jump into using the machine, right? If you are doing it, that means you were negligent in doing it. A reasonable or a prudent man would not have done what you did. That may be negligence, or it may be omission as well, right? So what is omission? Doing something which a reasonable man would do, right? Omission to do something. That means you failed to do something which a reasonable man would have done. Like take for example, when we visit the doctor, right? Usually doctor would ask, okay, are you allergic to anything, right? They would ask before prescribing the medicines, right? Sometimes they may ask, okay, fine, do you have any like health issues, right? If nowadays we are visiting any hospital or anywhere, right, they would ask, okay, fine, were you having fever, cough, cold, etc. in the last 1 week or 2 weeks? Why? Because those are the safety steps that they are taking. Based on that, maybe they would allow us to enter somewhere, or maybe they would proceed with our treatment, right? So that in that case, it is not that, right? If the doctor fails to ask, okay, fine, like before giving vaccine also might be they would ask, were you having COVID in the last, like 15 or 1 month, right? So those steps need to be taken. If they fail to do it, it will be omission. What is omission? Failure to do something which a prudent or a reasonable man would do, right? So act means you were not supposed to do something, but you still did it. That is negligence. Like using a machine without knowing how to operate it. Omission means failure to do something which you should have done, right? Like asking for some medical history, asking for like health condition of the patient and other things, right? Like take for example, even like if you go to a dentist, right, for some treatment, might be you want to like take out one tooth or something, right? Doctors would ask you for some basic questions, right? Are you like fine physically or not? They would check your BP and stuff, right? If you are going to donate blood also, they would ask for a few things, right? They would get some like tests done just to ensure that you are not having any of those like diseases or other issues, right? Like, and also they would ensure that you are meeting that eligibility criteria, right? You should not be like a child or someone, you should not be underweight and stuff, right? So if they are not doing it, that would be negligence, right? So negligence might be act also or omission also. Now, what are the essentials of negligence? Okay, so we basically have 3 essentials for negligence. First one is that the defendant owed duty of care to the plaintiff. You cannot simply make any random person responsible, right? Whomever you are making responsible, against whom you are filing a case, right? That person should have a duty as well, right? If there is act or omission from the side of another, that person should have a duty also. Okay, take for example, like negligence as a tort does not include loss arising out of breach of moral duty, but it has to be legal duty. What is the difference between moral and legal duty? Any idea? Between moral and legal duty.
Moral means like a traditional somewhere we have followed like that, ma'am. Legal means something we are authorized.
So moral duty as in something that, like maybe we feel that we should do. Might be it is like our moral duty that we should help someone who is in need, right? We should feed someone if someone is hungry. All those are moral duties, but law is not saying that you should go on feeding all the hungry people. That is not a legal duty, right? So we need to differentiate between moral and legal duty. When we are making someone responsible for negligence, it has to be violation of a legal duty and it cannot be violation of a moral duty, right? Take for example, if someone is having like a bakery, all right, and he is having like a lot of different variety of food available in his like shop, right? So if some beggar comes who was like very hungry, starving, and he asks for food, that please give me something to eat for free, I don't have money. In that case, if that shopkeeper, right, he refuses that no, I cannot give you anything for free, and as a result the beggar dies because he was very hungry, he was starving, the beggar dies just in front of the shop, right? In that case, we cannot hold this shop owner liable, right? He was not negligent. Why? Because maybe he was having a moral duty to offer some food to such a starving person, but he was not having a legal duty, right? Just because he was having so much of food, it was not his legal duty that he should be feeding people for free, right? So that means that would not be a case of negligence, right? We cannot hold that shopkeeper liable because he was simply having maybe a moral duty, not a legal duty, right? So first essential is that there has to be a legal duty from the part who has violated, okay? So now defendant's duty. Now we say that, okay, fine, he had a duty. Now, what was the extent of that duty? That would depend on the situation, right? How much of care you could have taken at that point in time, you should do it. Okay, so take for example, there was this case, all right, Rural Transport Service versus Belgium B. What happened in this case is, there was like a conductor of an overcrowded bus. All right, there was an overcrowded bus which was coming, and the conductor plus the driver, they allowed a passenger to sit at the roof of the bus. Right? Usually what happens, that is not allowed, right? People should ideally be sitting. If standing also, maybe 1 or 2 people can stand. It's not like an overcrowded bus, people are somewhere lying, hanging, that would not be allowed. On top of that, what they are doing is, they allow the passenger to sit at the roof of the bus, right? Now, unfortunately, the passenger struck to an overhanging branch of a tree when this bus was on extreme right. Right, while driving also, this bus took an extreme right, and there were some overhanging trees, and this person sustained injury and he died there only, right? As a result, the passenger fell down and he died because of receiving multiple injuries. Court held that there was negligence on part of driver and conductor. That means, what is the extent, like how much of care you should be taking, what is your duty, those things would depend on the situation, right? If you, first of all, being the driver or conductor of the bus, they should not have allowed a passenger to sit on the rooftop. That was their first negligence. After that also, they were not driving properly, they were taking extreme right. As a result, the person sustained injury and died. That means we need to see whether they were having a legal duty or not, and to what extent they were having the duty, right? So in this case, accordingly, they were held responsible because they were negligent in performing their duty, being a driver or conductor. Okay, similarly, there was another case, Mata Prasad versus Union of India. What happened in this case is, there was a truck driver who tried to cross the railway line. Railway line, you know, right? In between there would be a road, and in between there will be a railway crossing will be there. You have seen, right?
Yes, ma'am.
Yeah.
Yes, ma'am.
So what happens usually is in that railway crossing, there will be like gates, right? And some people would be there who would close and open the gate. They would say, okay, fine, train is coming, don't cross. Even people also, they would stop, right? Like vehicles obviously cannot pass because gate will be closed. People also, they would stop that you should not pass and stuff. So what happened in this case is there was one truck driver who tried to cross such a railway line, right? He was coming through road and he wanted to cross the railway line. But suddenly he was hit by an incoming train, right? While he was crossing, only an incoming train hit him. The gates of the railway crossing were open. Obviously, how come the truck was able to cross it? Because the gates were open, right? As a result, he was trying to cross, not knowing that a train is coming, and as a result, there was an accident. It was held that railway administration was negligent and were held for damages. That means if there is a railway crossing, if there are some people appointed there, those people need to do their function properly, right? If there is some negligence or other stuff from their end, the administration was held responsible. This also applies for your vicarious liability thing, right? Employer and employee. Even though it was some employees of railway who were negligent, railway administration was held liable. Why? Because there is employer and employee relation again. Right, so this also would be negligence. Why? Because you had a legal duty to perform your job properly. You failed to do it. That means it's an omission, case of omission, right? And what this one is, this is an act, right? That you did something which you were not supposed to do. You were not supposed to allow a passenger to sit on the roof of the bus. You did it. It was an act. And in this case, it was omission. You had a duty to close the door, like gate on proper time. You failed to do it. That means there is omission from the part. Is it clear? Act and omission.
Yes, ma'am.
Duty of care, right? So these cases you can also mention. This one you can also, like one case you can read and write for this as well, right? Vicarious liability as well. Now, second thing that we need to prove is the defendant made a breach of that duty. First, we need to prove there is a legal duty, right? And it was not merely a moral duty. Secondly, we need to prove that defendant made breach of that duty. Yes, fine, you had the duty, but did you fail to perform that duty or not? That also needs to be proved. So breach of the duty means failure to perform the obligations imposed by law. Obligation means obligation to take care while performing an act, or omission in a given situation, right? So in these cases, obviously it was like evident, right? The railway gate was open. That means definitely there was negligence, right? Driver did not come down, open the gate and try to cross it, right? It was open, so he was able to do it. So secondly, we need to prove that there was breach of the legal duty which was being imposed. Okay, and thirdly, plaintiff suffered damage as a consequence thereof. Whatever was the act or omission, whatever was the negligence from the part of these people, as a result of this negligence only, plaintiff has suffered loss. It was not because plaintiff was doing something wrong. Like we said, right, the horses only entered his premises. It was not like that, but because of this thing only, they suffered loss or they sustained loss, right? So that also would be a case. Like I have heard, right, when there is this railway crossing, what people would do if like train is stopping, right? People would try to cross the road. Like there would be like this joint kind of a thing, right, between two the bus.
Yes, ma'am. Sometimes leg will.
Yeah. So I think like people would cross under it or above it or something, like somehow they would like cross in between the train only when the train is stopping on a certain station. Okay, so that is like very risky. That can also lead to accidents. So if something happens like that, in that case, railway administration will not be responsible, right? And also there are like people posing and all in the railway line, sleeping and stuff. In that case also, we cannot make railway authorities liable. Why? Because people are only doing such stupid things. Railway authorities would not be liable, right? So what we need to prove is whatever loss is suffered by plaintiff, it is because of negligence from their part. right? And that person was not doing anything stupid like lying on the railway line and stuff. Okay, so that is the third thing which we need to prove. So these are the three conditions or essentials that we have with regard to negligence. If these three conditions are proved, there will be responsibility or liability of the other person. Okay, is it clear?
Yes, ma'am.
So what we have understood by far is if there is any sort of negligence, right, whether act or omission, we are complaining in the court, we need to prove that these three conditions are there, right? We need to prove there was a legal duty was violated. As a result, I have suffered loss, right? All the responsibilities are on the person who is complaining, right? That is the usual case. But there is an exception, which is called as principle of res ipsa loquitur. Have you heard of this before?
Yes, ma'am. The thing speaks for itself.
So what an example may be? So thing speaks for itself. That means in general, we need to prove there was negligence. As a result of negligence, we have suffered loss and all, right? But there may be some situations when the situation itself will speak its own story, right? We don't need to prove anything. It is so clear, it's so evident that by looking at the situation only, it will be clear, right? So in that case, whoever is complaining, if I am complaining, I will not have the responsibility of proving that, yes, there was a legal duty, it was violated, I have suffered loss. I don't have any duty. But rather, this other person will have a duty that to prove that he was not negligent, right? Because by looking at the situation, court will presume that, yes, you were negligent. Now tell us why you think that you were not negligent, right? That means this duty of proving would also shift. This defendant will have to prove that because of these situations, I was not negligent. All right, so that is nothing but res ipsa loquitur. For example, if there is a person who was operated only once in his entire lifetime, okay, and what happens is maybe he was having like stomach ache and then he went to the doctor, he got some ultrasound done and figured out that there is some like a piece, like a piece of cotton left inside his stomach. Now obviously piece of cotton would not be there in your stomach from birth, right? It has to, it's like an external thing, right? It has to be inserted. In that case, it's very clear that in your entire lifetime, if you were operated only once, that means it was negligent of those doctors and other medical staff. While getting the operation done, they were negligent and by mistake, they left one like piece of cotton inside the stomach, right? So in that case, it's very clear. The patient do not need to prove there was negligence, but rather medical staff will have to prove how they can prove, right, that they were not negligent. That is nothing but res ipsa loquitur. But in another case, if a person was operated maybe 6 times in his lifetime and there is a piece of cotton left, then he will have to prove that, okay, fine, it was negligence of this medical staff of the last operation, right? So maybe he can show all the ultrasound report and everything before the operation. Let's say before the operation, any external object was not there. After the operation, it was there. So definitely it was their negligence, right? So in this first case, it will be a case of res ipsa loquitur where the patient do not need to prove it. But in the second one, patient will have to prove that it was negligence of these medical staff only. This is clear, right?
Yes, ma'am.
So next is facts of the case are such that the natural inference immediately arising is that injury complained of was caused due to defendant's negligence. That means this situation is so clear that what thought will come in your mind for the first time is that, yes, there was negligence. Right? When someone is saying once only I got operated and then I'm finding out this piece of cotton left inside me. Obviously, we would think, first thing that would come to our mind is how negligent can the medical staff be, right? That is nothing but res ipsa loquitur, when this first inference that comes to our mind is that yes, they were negligent in performing their act. Okay. Secondly, the nature of the act is so clear and unambiguous that they itself tell the story, right? When you hear that, it's like very clear, right? You don't need any explanation, any clarification, any proof and stuff. It's very clear for us, right? So these two things need to be there in case of res ipsa loquitur, right? These are, you can say, like essentials also. Okay, concept anyways you knew, right? So there is a case which also explains this concept. So this was a case of 1966, okay? Municipal corporation versus Saubhagyavati. So what happened in this case is number of people died due to collapse of a clock tower in Chandni Chowk area of Delhi, right? In Delhi, there was this Chandni Chowk area, we all know, right? So there what happens is there was like a clock tower, all right? This clock tower was like placed there by Municipal Corporation of Delhi, MCD, right? So Municipal Corporation we have in all the different cities and things, right? And they would take care of all this work. So Municipal Corporation of Delhi, they had set up a clock tower in Chandni Chowk area. And because that clock tower collapsed, number of people died there. All right. So what happened is it was in full control of it. That means MCD only had installed it. They were only completely responsible regarding its maintenance. Now, this clock tower was 80 years old. For last 80 years, it was there in that area. And the normal life could be 40 to 50 years only. That means normal life of such clock towers is 40 to 50 years only. After that, you need to remove it because it would be damaged and stuff, right? With time, it would get damaged. So normal lifetime is like 40 to 50 years. After that, you should be removing or replacing it. Now, in this case, Supreme Court held that MCD. So what happened here is normal lifetime is 40 to 50 years and this clock was there for 80 years. That itself shows that MCD was negligent, right? They should have removed it once the period was over. So many times, like around like more than like 2 times, right? If it was 40 years, it is there for like 80 years. So it definitely tells its own story that they were negligent. They should have removed or replaced it. In this case, Supreme Court held Municipal Corporation of Delhi responsible for the negligent act. It was the duty of MCD to maintain and look after the clock tower and it failed to fulfill its duty, right? If they had installed it, if they were having the responsibility of maintaining it completely, they should have removed it also. So Supreme Court said that yes, MCD was negligent in keeping the clock tower there and as a result, people died. The court stated that falling off the clock tower tells its own story and the proper and natural inference immediately that we can think of is that the injury was caused by defendant's neglect only, right? So when we hear that, okay, fine, this clock tower was there for like 80 years, when normal lifetime is 40 to 50 years, definitely MCD was very negligent, right? So we don't need any extra information, extra additional proof or any other thing, right? So this also is a case of res ipsa loquitur where the first thing that comes to our mind is yes, MCD was negligent, right? Is it clear?
Yes, ma'am.
Okay. Anything you want to be repeated? Any points?
No, ma'am.